Okay, today we're talking about parole evidence rule. Last time we talked about the statute of frauds, and I made a point of pointing out not to confuse the two. So you pretty well understand the statute of frauds, but the parole evidence rule is probably still a little bit vague in your mind. So let's clear that up. And so one of the things about a contract is you have to prove its existence. And to prove its existence, if it's a certain kind of writing, it has to be in writing. If it's a certain kind of contract, it has to be in writing. So sale of interest in land has to be in writing, et cetera, et cetera. We covered that all last time. Now the other question in terms of a contract, if you do have a writing, or even if you don't have a writing, what are the terms of the writing? And of course you know the problem. If you have two people who are going to testify to an event, they're very likely not to be consistent with one another. That is, there may be some variation in what they remember having been said or not said. And therefore, a written contract is always a good ideal because it eliminates that problem of people not remembering exactly what's right. Now, of course, if you were in a contract dispute with somebody and you disagreed as to the terms of the contract, possibly you or the other side or both sides would think that the other side was intentionally lying, when in fact it may simply be that both sides are just misremembering, and that both sides, when they did contract, did not make themselves clear, did not insist upon the terms that they should have insisted upon, and just assumed that the other side would agree to those terms or had agreed to those terms when they had not. And so a lot of it sometimes is just simply confusion. So a writing also eliminates a lot of that confusion. But we did say that last time the statute of frauds was enacted not to avoid fraud between the parties, although it may have that effect. It was enacted in order to avoid frauds upon the court. So now what is this parole evidence rule? Well, what is the best evidence of what the parties have agreed to? Is it their actions? Is it their past dealings? Is it the agreement itself? So the parole evidence rule, as a rule, says, well, if you do have a writing of a certain kind, if that written agreement is present, you can go with the agreement as it was written, provided it meets certain requirements. And so let's start off talking. I want to proceed first with a hypothetical. Let's say that Arnold and his wife have negotiated the purchase of a house, and this house is the house of his wife's dreams. It's perfect. It's a California ranch. It has glass throughout. It's beautiful. And his wife just loves this house. And they've been looking for 2 or 3 years now and hadn't found any house that could compare to it. And so Arnold has negotiated this house of his dream. Ziggy, the seller, insists that he prepare the purchase contract that they will both sign in a week. Even though Arnold says he could easily do it, has experience doing it, knows how to do it, Ziggy insists. And so reluctantly, Arnold caves in and says, okay, you do it, but I want to see it a week before the signing. I want you to send me an email copy a week before the signing. Ziggy doesn't do that. At the closing, Ziggy arrives late with the contract and urges Arnold to quickly sign. Arnold, on the other hand, does what all of you should do. He says, no, I've got to read this contract. I'm going to read every line, and I might even think about some of the lines, and only then am I going to sign it, and it had better be the contract that we had agreed to. And he reads the contract and finds that the terms are not those they had agreed to upon a week earlier. Would you sign the contract? Of course you wouldn't, not as it is. But on the other hand, your wife wants this house, and the price is right. So there is a way around this. You can change the contract right there on the spot, but you don't want to sign it because of the parole evidence rule. Even though Ziggy says, oh, don't worry, I will agree to all the things you do. Now, how do you know that you remember correctly what the terms of the contract is? Even though you didn't have a signed written agreement, when you were negotiating with Ziggy, you made notes. And on your notes, you noted what was agreed to and what was not agreed to. So you could easily have prepared the document yourself and you know right away that this is not what was agreed to. So what is the parole evidence rule? Parole evidence rule is this: if all the parties have signed a written agreement which document was intended and purports to be a full, final, and complete statement of the contract between and amongst the parties. See, in this contract you have actually 4 parties. You have the man and his wife, you have Arnold and his wife, you have Ziggy and his wife. Okay, so all of them have to sign and agree. Then no evidence will be admitted or to vary or supplement the terms of such an agreement. So it has to be intended to be a full, final, and complete statement of the contract of the party. Now, what we would call this kind of contract would be a fully integrated contract. A fully integrated contract is one that cannot be added to, or the terms in it will not be something that you could challenge, provided that they are clear. And we'll talk about that as we go along. Integration. Integration is ultimately up for the judge. A statement that a contract is or was intended to be full, complete, and final is oftentimes, however, put in a contract. That statement, they're called integration clauses. Those statements are actually they actually create a rebuttable presumption that the contract is actually fully integrated. Fully integrated means what? It means it's full, final, and complete. That all the terms are there, that there was no change in the terms, and that everything is complete, in terms of the contract. And that would also include things like maybe there are some certain things that were required to be done before the closing on the contract. So you would want to make sure that those things are in the contract also. So the intent of the rule is to create a strong contract. Fully integrated contract is enforced precisely and exactly as the contract is enforced precisely and exactly as it's written if you have a fully integrated contract. So by all means, put that clause in there, but remember, it's a rebuttable presumption. Rebuttable presumptions can be challenged, and the judge could decide that in his view, the totality of the circumstances indicated that it wasn't actually fully integrated, although it said it was. So he's going to look deeper into it. So I said, how do you determine what the contract means? Is it the parties' actions? Is it their previous dealings? Is it the written contract itself? You could say that it's probably not just one thing, that the judge is going to look at all 3 of those factors in making that determination. Partially integrated contracts. Now, if you have a fully integrated contract, nothing can be added to it. Partially integrated contracts oftentimes allow something to be added, and even sometimes something to be changed, as we'll see. So the question is, how hard are you going to make the judge work? The judge doesn't like to work too hard. He likes to come in there, do his case, and get out on the golf course. So, he likes it if he's got a case to be heard, and in the afternoon he's got a case to be heard, and it's a contract case, and it turns out that one of the parties points out that there's no writing to prove the existence of the contract. Well, that's just perfect for the judge, because then he can go play golf. He just says, case dismissed, and that's it. Of course, the other side may raise an objection and may have an exception, and we covered the exceptions to that last time. Anyway, ideally the parties will state the terms of their agreement completely and fully and finally. These are called fully integrated contracts, and the terms then cannot be easily changed or added to. In other words, you have to find some exception to the rule to allow you to change it. Are there exceptions? There is. One big exception is called vagueness or ambiguity. If the parties, for some reason, omit a term, well, omit a term is not a fully integrated agreement. But can you tell that by looking at the contract? Maybe, maybe not. A judge with some experience knows what to expect, what you see in a contract. A person who's bought a house probably knows what kinds of things are in a contract, what you expect to see. What's in a contract for sale of goods? They're oftentimes very similar in many ways. The kinds of things that are in there, we know what they are. And the judges know that too, And that's why I say the judge will make a determination of whether it actually is fully integrated, separate and apart from some clause that you put in there that said it was fully, finally, and complete. Okay, so that's just the reality of it. Fully integrated terms cannot be changed or added to. So if it is fully integrated, he would have to decide that it's not fully integrated. If it's not fully integrated, it may, however, still be partially integrated. If the parties for some reason omit a term or are vague, so ambiguous, then it is consistent. Then if the term is consistent, if the omitted term is consistent with their agreement, the judge may find a partially integrated contract, in which case the court may hear evidence and argument. So the court has it up to his option. Remember, this is a guy who wants to get out there on the golf course. You don't generally want to leave it up to a discretion of anybody, especially some stranger you don't know. Did you vote for him on the last election? Well, do you really know him though? Obviously, if you voted for him, you thought he's a good guy, but is he really? How well do you know him? So basically, you want to make sure that you have spelled out all the terms that you can, and there's no doubt as to that they're clear and understandable by any reasonable person. Okay, there we go again with reasonable, right? Okay. It may be found to be partially integrated, in which case the court may hear the evidence and arguments supporting or denying the additional term's existence, or evidence that a change was made to a term or to terms. In other words, you could have subsequently modified a contract, even orally. I don't know that we're going to get into that. We maybe should have done that when we talked about statute of frauds. But you can change a contract subsequently. Sometimes, however, if it's a contract that's required to be in writing, that has to be in writing also. On the other hand, sometimes on certain kinds of contracts, like sale of goods, where there's an amount of money involved, if the contract no longer is within the statute of frauds, then you maybe don't need to have a writing. Also, some contracts will say that any change to the contract requires a writing. So, these are a couple of things they have to watch out for as to why you would need a writing to change the terms of the contract. If you change a sale of goods contract in a way that is no longer over $500, it no longer requires a contract. So the change wouldn't require a contract in some courts. Other courts might hold that it still requires a contract because the original contract was required to be in writing. But that's up to the courts in the various states because we have a federal system. So if the parties for some reason omit a term or are vague, then if it is consistent with their agreement. So the judge is going to look at the entire agreement. He's not going to be going off on just the words of the contract. So one of the things that I think that many people don't understand about the law and judges is that judges not only apply the law according to principles of law and rules of law, they not only apply those rules and they follow those rules and those principles, but they also follow the provisions that the rule of the law is not just about logic, but it's also about experience. These judges usually are men of some experience, and therefore they can sometimes say, well, this is just not right. And they can tell the difference, and that's why I say if they're not just going to look on that fact that, well, yeah, you get a rebuttable presumption. They're going to look and see whether or not there is actually full integration in that contract. Does it appear to be some term is missing? That's usually found in contracts. Why isn't this term in there? He might ask the litigants, why didn't you put a term in there setting the price? He can actually, under the Uniform Commercial Code, supply the price in some cases, but he has to be reasonable doing it. And there's certain rules that apply to his doing that. So he knows those rules, and he'll apply those. But he has the power, some discretion in saving a contract that was poorly drafted, poorly written, that is. Okay. So it has to be consistent with their agreement for him to allow something in to clear up the vagueness. And he'll call this a partially integrated contract then, if he decides to go into it. So, well, it's integrated, but it's partially integrated. There's something been left out, It may be something omitted, or it could be something that's vague, in which case the court may hear the evidence that supports the inclusion of this term. Why should this term be included when there wasn't a term? Why shouldn't he just go with what he thinks is the reasonable term? Well, judges don't like to do that. They like the parties to make their contract. So he has an option of saying, I'm not going to make this contract for you, or I think this was a reasonable term that you put in there, so therefore I'm going to allow you to present the evidence supporting that, and I'm going to allow you to argue for that. And so supporting and denying the additional existence of evidence that a change was made to a term or terms after the contract was written. And that reminds me, if Ziggy says to you after backdooring you, that's what Ziggy was doing here. He was backdooring. He went through and he agreed to certain terms, and then he rewrote the contract in a very silly way, and there was a number of things that had to be changed in that contract, including the fact that he was required to give a good warranty deed, which he had changed to a bad deed, a quitclaim deed, which is not what you want when you're buying a house. And so that was very stupid of him to do, because there was no reason for him to give a quitclaim deed. There was no challenge to the title. The title had been searched by the other party. He knew the only reason he agreed to go through and with the contract was because they changed the contract, and it said that it was a good warranty deed, and other things were changed. But also he knew that the provisions were there. He knew that the conditions for the sale were right. He had the house inspected. You need to have a house inspected. You need to have the title searched. Those are two very important things to do. And you want to look at a house before you buy it. And you may want to actually check on things like, when I was looking for a house, it was very important for me to have a house outside of the city limits of Cincinnati, because I worked in Indiana and I didn't want to pay Cincinnati city taxes. And if I lived in the city, I would have to pay those. And they were like 5%. And I think Indianapolis has a very similar provision. So if you're down there, you might want to live in the suburbs. On the other hand, there's certain things that are nice about being downtown. If the money's not a problem, why not? So nothing wrong with that. Ideally, the parties will state their terms. And so go on. Okay, let's go to the next slide. Exceptions allowing alterations. Subsequent modifications. You can alter the contract by subsequent modifications. It's best to do it in writing. It can be done orally sometimes, sometimes not, because you have the statute of frauds things. So as long as the contract is within the statute of frauds, or if it goes into the statute of frauds and it wasn't previously in the statute of frauds, then you need a writing to prove its existence. So that's one way you can change it. Incomplete contracts. Sometimes parties even negotiate contracts that are intentionally left incomplete. A term is going to be supplied later. Perhaps they have a issue about the price of some commodity. And rather than set a fixed price, they decide to allow some trusted party or some trusted organization to fix the price for them. And so it's an incomplete thing. So that's going to be, the price is in a sense, if there's already a price term in there, it just tells you the way the price would be fixed. Sometimes it's related to a recognized listing that lists prices for things. What are the price for wheat? You can look it up on the Wall Street Journal. Okay, so you could use that. Anyway, ambiguous or vague terms is another way, another exception to allowing alterations. So ambiguity and vagueness are different in their aspects. Ambiguity usually relates to one word, where vagueness oftentimes relates to a number of words. In any case, both of them make the contract unclear. So one of the things the contract needs to be, if you're going to put it in writing, you want it to be precise, you want it to be exact, then you'll get it enforced just the way you want it. But if you leave it unclear, if there's something that's not clear, then a reasonable person doesn't know what it is. The judge is going to look at it and says, well, I don't know what you meant by this. What's right? If he can't see, if he doesn't see that a reasonable explanation of what the agreement was, that there's some sort of fixity to that agreement, he'll maybe just throw the case out. Pre-contractual facts may be admitted, however, to clarify the intent of the parties. So one of the things you would want to maybe argue for a judge who says, "Oh, I don't know what this term was supposed to be. It's vague here. It's not exactly clear, or it's ambiguous." Well, you say, "Well, judges, maybe you got some evidence that you could introduce in there, and the evidence that ideally suited for that is recommended for that, are what we call pre-contractual facts." Okay. Prior course of performance. So these are pre-contractual facts useful for clarifying the terms of contract. If and only if the written terms of the contract are judged to be incomplete, suspect, ambiguous, vague, then the following may be admitted to clarify what the contract was meant to say, what this term was meant to be. So one thing would be prior course of performance. Another thing would be course of dealing. Another thing would be trade usage. Now let's take a case that dealt with this situation. I call it the chicken case. In the chicken case, there was supposed to be 3 shipments of chicken. And the 3 shipments of chickens were described just simply as chickens, no more than that. Just he was to deliver chickens to a restaurant, and so they were to be installed every 2 weeks. He was going to send a shipment of chickens to the restaurant, and the practice is in the restaurant business. When a shipment comes in, you have somebody like the chef, and oftentimes it is the chef, the top chef, maybe goes out, or somebody he designates goes out, examines the food that's being delivered to see whether it's suitable or not for the restaurant. So the chef goes out on the first shipment, looks at the shipment, and says, "Yeah, this is good." He accepts it because it was suitable for broiling and frying. Then the second shipment comes in. He goes out on the dock. He says, "What's this garbage? You got some little chicks in here. Some of these birds look like they're diseased. They're skinny. There's no meat on those bones. These are not chickens. These are garbage." Okay? And the seller insisted that they were chickens because they fit the dictionary definition of chickens, and therefore, if the judge wanted, or if the restaurant wanted other kinds chickens that were suitable for broiling and frying, it should have put that term in there. It should have explained it. And that would clarify it. And it exactly would have clarified it if they did that. But should they have to do that? And so there was a dispute there. The seller saying, "I've complied with the terms of the contract. I stood ready to deliver the chickens I was required to," and he just canceled the contract completely. He said he wasn't going to take the third shipment even. He sort of totally canceled it. Well, if in fact the chickens are not conforming goods, then he has a right to do that. But the seller's arguing they're conforming because they fit the dictionary definition of a chicken, and that's all it says in the contract. It doesn't otherwise define what chickens mean for a restaurant. Now, we go back to what we talked about before. Was there a prior course of performance? In this case, there actually was. They had previously dealt with this supplier, and he had delivered chickens that were conforming goods. And then, was there a prior course of dealing? Yes, but the prior course of dealing is that first shipment of chickens. So in this case, they had dealt with them, and therefore that was also there. So you have the prior performance, you have the prior dealing. The prior performance is actually the first shipment. I'm sorry, I made that mistake. Prior performance is the actual first shipment under that contract. The prior course of dealing is those prior contracts in which they had actually done that. So I was thinking chronologically rather than according to the categories. And I should have started with prior performance, because prior performance was that first shipment. So they performed part of the contract, and they performed it right. But in the second shipment, they screwed up. And course of dealings, provides good or strong evidence of the party's intent. So by the fact, the course of performance, the fact that they originally delivered the correct kind of chickens, indicates that they knew what kind of chickens they were supposed to be delivering. Otherwise, why didn't they send garbage in the first place? It's a lot cheaper, and they'd make more profits if they could do that for 3 shipments, right? But they didn't do that. They sent good chicken. Um, and course of dealing also indicated the same thing because they had previous contract. Why didn't they send garbage in those contracts? Because they wanted to have more dealings, right? And they didn't figure they'd get away with that. Trade usage can also be used, although it's the weakest of the three. The strongest one is the prior course of performance, the fact of how they performed under this contract in the first place. Course of dealing is a weaker kind of performance, and therefore course of dealing is, however, nonetheless strong. Trade usage is strong. Trade usage, what you do is you put some expert who knows about restaurants and knows that when chickens are ordered by a restaurant, what kind of chickens are intended to be contracted for. What do restaurants contract chickens for? Do they actually buy chickens that are garbage and go through it and pick out that what they can use and throw out the others? No, they don't do that, do they? And so all of the pre-contractual facts support the arguments that you don't need to explain chicken. Should you do it? Maybe you should, just to avoid litigation. But you shouldn't have to explain that, because anybody with any common sense, any reasonable person would say, well, I know what kind of chickens that the restaurant was expecting to get, and they ought to get what they were expecting to get. They ought to get their reasonable expectations, and it's reasonable for them to expect that some supplier is not going to be doing something stupid like delivering garbage. A man like that's not going to be in business very long, I think. Anyway, so that's comes with pre-contractual facts. What is the best evidence as to the integration of the parties' agreements? What is the best evidence as to the contract of the parties? Their past dealings, their actions, their present actions, the agreement itself. Well, the rule, if it were to be strictly enforced to the letter, so to speak, I suppose would say, oh, well, it's got to be the agreement. But here we see with this exception, which is part of the rules, the statute of fraud is in one part of the Uniform Commercial Code. In another part of the Uniform Commercial Code, you find the exceptions to it very close by. So you just stop and look just at the rule itself, and then not go down and see where it gives you the exceptions. And if you did that, you'd be missing a lot of what the law is. So the law has been hammered out over a period of years. And one of the things that we have learned in our system of law, in Anglo-Saxon common law, one of the things that was learned is that the law needs to be adjusted by experience as we go along. Now let's get back to that first case with Ziggy. What to do with Ziggy? You want to buy this house, but you don't like what's happening to yourself. And as far as you're concerned, you might want to throw the guy out. You might want to tell him to go fly a kite. He's been trying to sell the house for 2 years, and now you know why. He's a jerk. Okay, he doesn't know how to sell a house. Your instincts tell you this man may be lying about other things, and indeed he actually was. Actually, there was more things that were wrong to that house that he knew about. Probably, certainly, he knew about them, but he didn't disclose them at the time. And they were things that couldn't be easily discovered by an inspector, which is unusual. Usually inspectors are very good. They can catch most everything. But sometimes there are some things that they can't catch. So, your instincts tell you you don't want to deal with this man. You never want to deal with a guy who is shoddy, who's constantly telling you one thing and doing something else. So by the fact that he told you he would prepare the document according to your agreement, and then he shows up with one that is nowhere close to being the agreement, that has to be changed on every page, not just one place on every page, but several places things have to be changed, all of which maybe he read about in some book that advised people on how to backdoor. I saw that book, actually. Okay. And awful kind of things. You don't want to deal with these kind of people. They're not good people. They're going to lie to you if they can get away with it. So you just got to be on your guard. And the best thing is not to deal with them in the first place. So you're going to deal with them anyway, because your wife wants this house, and you want the house too. It's the right price, right neighborhood. You basically sit him down and say, okay, we're going to change this agreement. And he says, oh, he had prepared it on a computer. He doesn't have the computer. He doesn't have a flash drive. He can't change it, he says. I said, no, you can change it. The old-fashioned way. You take out pen and you cross out things on inside the document. You make proofreader marks. You cross out things. And then you add things using proofreader's marks. And every change that you make, all the parties initial, that is Ziggy's wife and you and your wife, all of you initial the changes, because you have to initial all the changes to the document, and you put in there whatever necessary. Sometimes you've got a little arrow going outside and says CA on back, and then on the back of the page, if you're fortunate that he had not actually used both sides of the pages, on the back of the page maybe you can write something that's rather long that's needed to be in there, that was supposed to be in there anyway, and you've got your document to show that that was actually, you've got your notes to show that that was actually supposed to be in there. And if he doesn't like it, then fine. If you won't agree to it, then you say, well, we never would have agreed to it unless these were the terms. These were the terms we agreed to, and we're not going to allow you to backdoor us. Sounds pretty bad, doesn't it? And it is pretty bad. So that's a valuable lesson. So make sure that when you get a contract that it says what it's supposed to say. And that'll be it for today. Thank you.